This is Attorney Christopher Ripley. I am an attorney with CCSK Law. Let's dig just a little bit deeper into the Indiana Medicaid process for just a few minutes. Medicaid rules are necessarily strict. First, they're informed by the Federal Social Security Act. So the state of Indiana only has so much leeway in establishing how the provisions of that act are going to be implemented within the state of Indiana. They can be more permissive, but they are bound by the Social Security Act and how Medicaid benefits are going to be provided to Hoosiers and how eligibility is going to be established. And the way that act is drafted, and to a certain extent by necessity, there are strict lines and strict limits on when an individual can be eligible. Now, the first strict limit, and particularly I'm talking in the context of nursing facility or waiver Medicaid, so somebody basically needing nursing facility level of care, either in a facility or in the community at home, they are going to need to be considered aged, blind, or disabled, and they are going to need to be required to need what we call nursing facility level of care, which is requiring assistance with at least 3 activities of daily living. And that can be things like sitting, standing, transitioning, hygiene, medication maintenance, food preparation, and so on. But they're going to need that care level, and that evaluation is going to need to be made by, say, a facility when somebody comes in, or by an area agency on aging if somebody is, say, making a Medicaid waiver application. And so again, that's a strict limit. Next, they're going to have to match the income test, and so that is having income that in the month, gross income that is less than what the current special needs limit, which right now is around $2,400. It's adjusted each year, but that is a hard limit. If you go even a penny above that limit, you're going to need to make additional arrangements such as the use of a qualified income trust. And if you have that trust established, it needs to be funded every month. And again, that is a hard numerical limit. If somebody misses that planning and that implementation by $1, well, then that can mess up eligibility for that month. And so this is it's hard numbers. It creates very sharp edges for folks. The third test is the resource test, and you'll hear these numbers thrown around quite a bit. For a single individual, it's $2,000 of countable assets as of the first moment of each month. For a married couple where they're both getting eligibility for Medicaid, it's $3,000. If there's a spouse in the community, they've got their own special exemptions off to the side, but that applicant still only has a $2,000 limit. Again, if at the beginning of that month, that total stack of countable assets has a value of $2,000.01, then that's ineligible for that month. And so that's how close we have to cut things. We have to be correct down to the penny. Again, hard rules have sharp edges, and Medicaid is full of hard rules. And so we need to be very, very careful when we plan to make sure that we have exactly the correct information, we know exactly where the math is sitting, and frankly, we plan ahead so that we have time to build in some cushions. Maybe we're not aiming at 2,000. Maybe we target having 1,000 for that eligibility month so that we make sure that if an asset shows up that was unexpected, we've got a little bit of wiggle room. So all of this boils down to the Medicaid system is itself built on very hard-edged rules, and the only way to get around those rules is to plan ahead. If you need to make a sharp turn, you don't do it the moment you're entering the turn. You look at it ahead of time, you begin slowing down, you make sure your car's pointed in the right direction before you go into the turn. If you'd like more information or have any questions, please don't hesitate to contact us at CCSK Law, 57 Michigan Avenue, Suite 101, here in Valparaiso, Indiana, 46383, or give us a call at 219-230-3600. Check us out on the website at ccskallaw.com.